Good morning, everyone. My name is Paul Shamplina. I'm with Paul Sowerbutts, Head of Legal at Landlord Action. It's a pleasure to have you on our webinar today. This webinar is brought to you by Total Landlord Insurance as our sponsors, powered by LandlordZONE, and I'm the founder of Landlord Action. So 3 companies within the Hamilton Fraser family. A big topic that is out there for landlords, obviously, is the abolishment of Section 21. Landlords are really fearful of Section 21 going. We're going to do a deep dive and explain in some detail about what it's going to look like when Section 21 goes. But we wanted to do a webinar about the here and now, evictions and what's changing and where we're at. So let me just now move the slides over. Moving over, so just bear with me a second. Just so what we can do is now tell you about what is going to be happening in the future on evictions. So let me just give you a bit of background about Landlord Action. What Landlord Action is a company I started in 2000. It's now 23 years old. We have 22 staff at Landlord Action. We do approximately about 2,500 instructions a year. The makeup at the moment, and it's never been like this before, is 60% of the business we get for serving notice now and issuing court proceedings now relates to Section 21, and 40% is now Section 8. Up until a year ago, it was always the other way round. What I have written about in the press and I have said in the media on various different media platforms, I was on Channel 4 News last week, is that there is an unprecedented amount of landlords now leaving the sector. And it was a worry of mine some 3 to 4 years ago because, of course, of what is happening with regard to Section 24 and the abolishment of mortgage interest relief. You've obviously had the higher interest rates that came in last year, where obviously some landlords have gone from 2% up to 6%. And then, of course, you have the Renters Reform Bill coming in, you have EPCs, and for some landlords, it's become enough is enough. What has been a big challenge has been the amount of rent rises for tenants. Remember, the tenants are the landlord's customers out there, but we are seeing lots of instructions at Landlord Action, Paul, of landlords want instruction Section 21, don't you?
Yeah, absolutely. Yeah, the purpose, is always difficult to ascertain exactly why a landlord wants why enough is enough. But I think wanting to sell, wanting to
is the biggest reason we're finding.
Absolutely,
yeah,
to get out. I'm afraid
it's definitely a bigger reason. So what we do at Landlord Action, we offer a 3-step fixed fee process for serving notice, issuing court proceedings, and arranging to get the bailiffs, if needed, to evict the tenants. We're regulated by the Solicitors Regulation Authority, and we are commentators when it comes to landlord and tenant law. Just want to give you an overview of our company at Hamilton Fraser. We own lots of brands within the private rental sector. So Total Landlord Insurance, we insure the best part of 20 to 30,000 properties for landlords with regard to flood, fire, malicious damage, and so we cover the landlords and protect their property, which is their biggest asset. One of our marquee brands, which a lot of you landlords would have heard of, would be My Deposits, the deposit scheme. We protect the best part of 1.2 billion pounds worth of deposits with over 150,000 landlords that use our deposit scheme. Obviously, LandlordZONE, which this webinar has been powered by, we will give you QR codes during this webinar so that you become members of LandlordZONE. It doesn't cost you anything. We have breaking news on a daily basis and information and guides and documents that you can sign up for, and it doesn't cost you a penny to become a member. We also own Client Money Protect, which is a government scheme with regard to client money protection for letting agents, as well as the property redress scheme, which is a redress scheme for letting agents. There's only 2 schemes out there. We're the second, there's the property ombudsman and the property redress scheme, and we have over 18,000 letting and estate agents that are members, so meaning that the landlord and the tenant do have redress as the consumer. We also have a referencing company called Tenant Verify, which you can Google as well. So we are literally a one-stop shop out there for landlords and letting agents. I am pleased to say that we have now over 500 attendees on this webinar. When we are going through the content of this webinar, it's going to be the best part of 45 minutes to an hour. Please fire your questions over to us and we will do your live questions at the end of this webinar relating to any of the topics with regard to evictions. Just my background, I've been in the legal field since, I worked it out now, since 1987. I started going to court 16, 17-year-old. I used to go to many of the county courts. I can say now, and we will explain this during this webinar, I've never seen the court system as worse as it is now. I issued my first possession claim while working at a firm of solicitors in 1991. We know the buy-to-let industry really started in 2002, 2003, but the delays and the lack of resource out there. There's 170 county courts in England and Wales, and the delays are becoming a big problem, aren't they?
Certainly are, Paul. I mean, whether you're at that initial stage of issuing the claim, I mean, to be fair to the HMCTS, they have brought that down post-COVID, but now it's all shifted to the sort of third stage, and the bailiffs going around to evict. It's just going from weeks to months to
it's becoming a nightmare, and we're going to do a bit more detail relating to bailiffs later on. So my background is I worked in law firms. I used to be a private investigator and a bailiff. I started Landlord Action in 2000 because I was frustrated with solicitors charging too much money. So me and my former partner started a fixed fee eviction service where we would also give advice to landlords. And then I started to do a lot of media and I do lots of letting agent training, as well as I do a lot of training courses for landlords as well. Got one on the 19th of October, which is on a website called paulshamplina.tv. But also we do a lot of advisory work at this business with the government. And obviously the latest thing that we're working in the government has been the Renters Reform Bill, and you can ask us more questions later on. But my main job is Chief Commercial Officer for the group, overseeing sales for the group. Paul, do you just want to give us a bit of detail about your background?
Yeah, thanks, Paul. I was brought into to Landlord Action about 2.5 years ago now to help expand Landlord Action's offering. We are moving into regulatory work as well as the eviction, which is our bread and butter. But also handling more complicated cases as well. You know, landlords are facing more and more difficulties, and you know, I'm coming to help support and guide through. Experienced for 20 years as a solicitor, acting for both landlords and tenants. So I know both sides. I think I've got a deep knowledge of the area in which we're dealing with, which broadly, you know, housing law, landlord and tenant, property litigation, all those areas, all types of landlords I've worked for. And I ran my own practice for 15 years. It was mainly legal aid, working for tenants, but as I say, it gave me that experience of understanding what motivates a tenant, and I think I brought that to Landlord Action to help with Landlord Action clients. Very key, keeping costs down. That's something that's important with legal aid. It is also important here. I'm very proud to be part of the fixed fee system that we offer.
Thank you, Paul. And on that point, actually, just before we move on, with regard to tenants, there was something that came out a few weeks ago about tenants getting more support with regard to legal advice. Do you want to explain what that is and what the impact that could be on court cases and to landlords?
Yeah, well, the what's on the tin basically is to sort of try and avoid court action. That's the point of it. The housing, let's get this right, the Housing Loss Prevention Advice Service, I think it's called,
right,
goes hand in hand with another mouthful, which is the Housing Court Possession Court Proceedings. Right. I got that slightly wrong now. Right, but anyway, there's a sort of legal aid funded system at the courts, been there for quite a long, most courts for many years. That's now going to be enhanced with this prevention or housing loss prevention service. And essentially what it means is at an earlier stage, a tenant's going to have access to legal advice, free legal advice. It doesn't matter your means, so you could be, a millionaire tenant, you're still going to be entitled to that. But the idea is that early on in the process, tenants are getting advice. So the way that it's working in practice, we've already seen it with since the 1st of August. We're serving notices, and on the bottom of the guidance that goes with the notice, the prescribed form that the notices on the Section 8 and Section 21, there's a whole block about this new service, where you go, what you do, and who's and how to access it. So the idea is that tenants will be once they get their notice, will be seeking that advice at an early stage.
But me being cynical, and I've been doing this a long time, it's quite rightly a tenant should always be able to access legal advice. You've been a duty solicitor, I've run a law firm for many years. The problem that does happen is councils are still telling tenants to stay put and waiting to be evicted, and all they're doing is kicking the can down the road, because the biggest problem is we have a massive problem when it comes to temporary accommodation and obviously social housing. Is this going to be a problem for landlords where there could be possibly sham defences?
It could be, yeah. I mean, look, the point is that that's what it's put on the tin, but actually the reality could be. And I put my neck on the line here, and been criticised for saying this, but it does seem to me there's an opportunity here for solicitors acting for tenants to sort of put in defences that maybe or raise issues that aren't
to delay things. And that is going to be a bit of worry. I mean, look, if you've got a landlord that hasn't carried out his compliance, hasn't carried out his responsibilities, the tenant hasn't had to walk hot water for 6 weeks or whatever, quite rightly a tenant should defend and counterclaim. Quite right, you shouldn't have landlords that don't comply, and there is a defence and counterclaim, and it might get set down for trial. But I have seen this many a time when that is the biggest problem. I
mean, where a solicitor gets involved, they will look to dot every I, cross every T, and make sure that there's nothing missed. And that's right to an extent. But where you sort of, I had a case a couple of months ago. We did settle it just before we went into court, so that was fine. But I was sort of saying right early on that this matter should be settled, and the solicitor just ignored that. They had legal aid. I sort of made representation to the legal aid agency, but unfortunately they got a backlog and they couldn't look at those representations until after the trial. It was a nonsense. So and it did get to court, but just before the court we settled, and that could have been sorted out a lot earlier.
So that's something to look at, maybe worry about. And but if you get all your ducks in a row, I mean, I must say that from landlords, and I would say this is, issuing a possession claim, going to court, serving notices. I was involved in the deregulation. I was involved in help drafting the Form 6A. I gave evidence on the Deregulation Act and evidence relating with retaliation eviction in 2014. It's now the hardest it's ever been when it comes to issuing possession claims. Bearing in mind, we've had COVID, and it feels like a distant memory. And obviously there were suspensions of evictions for 6 months and notice periods for 6 months. And we see what's happening in the court system, and you can't think about abolishing Section 21 until you have, and we're going to talk about this, the strength and grounds of Section 8, more resource in the court system. We were talking about housing courts. Housing courts has become, and that's gone off the table. In 2019 in October, I went to housing court working group in Leeds and was speaking to judges, and it's a worry because we should have designated. I was a bit cynical at the time, but actually thinking about where we're at now, we should have designated courts. We should have designated lists. We should have specialist judges that do this. So look, I'm going to run through some stats, which I put this slide deck together last week, just some updated stats on the marketplace where we're at. Now, what I would say to landlords is there is landlord panic that's going on at the moment. The market's hardened, the interest rates have gone up, rents and property prices were becoming unsustainable. I think we all have to agree with regard to that. But if you are a long-term landlord and you are incorporated, I would say the pluses for landlords is there's never been so many tenants now vying for one property. It is tough being a tenant because the tenants are paying the best part of 35 to 40% of their wages towards rent, which I think is becoming unsustainable, which is a big chunk of money. I live in northwest London. 2-bed flats in Barnet are going for £1,900 a month. The best part of 2 years ago, they were going for £1,200–1,300 a month. It is going crazy. So look, let me just tell you about this. And this is a worry. And I've even got a meeting with my local MP, Teresa Villiers, in the next few weeks. And I would recommend to landlords, if, you know, to actually highlight the rental stock crisis that we are in. And I think it's only going to get worse, unfortunately. But if you are a landlord, you are in the market, you will have a stream of tenants that are going for your property, and you will be able to pick the best tenants on paper than you ever have them been before. You know, I spoke to one letting agent. I do letting agent training. I spoke to one letting agent. I think it was about, it must have been the best part of 4 or 5 weeks ago. They do open house viewing now, letting agents. They had 85 tenants going on a block viewing. That's crazy, isn't it?
Yeah.
It's not even an auction. I mean, but it's becoming an auction because, of course, now landlords are saying, right, well, who's the best? What do we do? Who do we go for? I'm going to go for it. And then, of course, you're getting tenants that are trying to outbid each other.
Yeah.
So it is really desperate times for tenants. So look, let me give you some of these stats. Now, this is a worrying stat that I picked up literally last week on a stat from Savills. 153,000 properties were sold in the private rental sector last year. So that's 153,000 properties that have come out of the sector. Think about how many families or how many couples that are coming out. And of course, what's happening is now, as we're saying with landlord action are getting more instructions. We're busier than we've ever have been in 23 years. We're having landlords saying, I want to serve a notice. What is going to happen is when you have the abolishment of Section 21 coming in a couple of years, you will get further landlord panic because they're going to think, I can't use a Section 21. Bearing in mind it has a 6-month lifespan, and then you might get landlords that are just serving notices. And the sad thing about this, when landlords are coming out of the sector because they've had enough, or, you know, obviously their challenges are going to be capital gains, is that you're having good tenants that are being asked to leave. And of course, when they do leave a property, where are they going to go? Can they find somewhere of the same budget, the same type of rent? Because historically, landlords don't put rents up, but they did put rents up when they were forced to because of their interest rates. 12% of National Residential Landlord Association members sold properties in the last 3 months. On average, 20 tenants are viewing one property. Landlords with buy-to-let mortgages have been in arrears has increased 28% in the last 3 months. 4.6 million houses, 19% of the housing market is the private rental sector. There's 2.74 million landlords as of 2021 declared tax returns. There's a feeling that that's going to obviously decline. Okay, 8% of landlords out there have over 20 properties. These are stats that I've just picked up, and I just thought it would be good to share this with our people that have registered for this webinar. So what I want to talk about now is we're going to talk about the notice periods of serving a Section 8 and a Section 21. Historically, landlords didn't really like serving Section 8 notices because they didn't really understand them, and they were for breach of tenancies, and they were more complicated than a Section 21 notice. So a Section 8 notice is served when there is a breach of tenancy. So the tenant has breached it, and generally a tenant breaches a tenancy 95% of the time because there are rent arrears, Paul. Yeah. And when there's 2 months rent arrears, as of the day you serve the notice and as of the day you go to court, it is a mandatory ground. It means that when you do go to court, the judge has to grant a possession order. Okay. There's gonna be currently is right, Paul, 10 mandatory grounds that are going to be used.
That's what there are at the moment.
Yeah. Okay. And name me some of those mandatory grounds, because a lot of the landlords that are registered wouldn't really know.
Well, many of them are rarely used.
Yes.
The grounds relating to religious properties or even educational establishments are, rarely used by most landlords. But the rent arrears is the mandatory one. Is the mandatory ground, as we said, is 95% of notices are that. But there is also, and this is something that's we come on to when the changes come in, is the sort of notice of the landlord wants to move back into the property. So at the moment, we'll come back to this, you've got to give prior notice to the tenant to say, I want to move back in at some point, or I may want to move back in at some point. As long as you've given that notice, you can use that ground. It's mandatory. The judge has to give you a possession order. If you've given notice before the tenancy started, you then decide you want to move in, you give your notice, ground 1, and the judge has to, similar with ground 8, as you say, Paul, on the date of the notice, the rent arrears have to be 2 months, and at the date of the hearing. Obviously, we'll come on to this as well, a trick, if you like, or a game that the tenant will play is they'll pay off some of the arrears, probably not all of them, get them below the 2 months, and then you get to the court and the judge can't make that order. So the mandatory grounds are there. As I say, there's 10 of them. They're the 2 that are mainly used. There's an antisocial behaviour one, which is quite uncommon in the private sector.
We're going to come on to antisocial behaviour because that is a way with regard to punishment. And I think also the reason why a lot of landlords, because look, trying to collect money from a tenant when there is rent arrears owing is most probably one of the hardest things to do, because bearing in mind we have a very busy debt recovery department, don't we, at Landlord Action? We do a lot of tracing and debt recovery, but of course the tenant has to have some sort of assets or a job for us to be able to try and collect the money. Most of the time landlords write it off and they go down the section 21 with not the section 8, or if they go to court and get a possession order and a money order, they don't enforce it. So if they don't enforce the money order, it doesn't become a county court judgment.
That changed after COVID. Obviously, the arrears were a lot higher. But
the arrears went a lot higher, and we saw a lot more landlords, because there was delays and there was loads more rent arrears over the course of time. We saw a lot of landlords thinking, clearly the tenants have taken advantage because of COVID. You know, we had the amount of cases we had where there was more than £20,000 rent arrears owing, was I've never seen anything like it. And we were seeing landlords under our fixed fee offering, trying to pursue tenants, tracing them to a new residential address and finding out their employment address, doing an attachment of earnings, or we were using high court enforcement officers to try and collect the money and attend a new address.
I mean, there's a lot of timing involved there. You know, immediately after the order, probably not a great time. They've got to get back on their feet to a certain extent.
Yeah.
But the order itself would last for 6 years, so you've got the time to enforce. And as you say, we started doing that post COVID, and I think it's helping landlords out a lot.
Yeah, it has been helping out. We've collected quite a lot of money actually in a really difficult market. With a Section 8 notice and Section 8 proceedings, you have to have a hearing date, and these hearing dates are listed for 5 minutes. And I think that the biggest problem that I see, and as I said, it's harder now than ever before issuing a possession claim. When you go to court, you know, what we do is we have someone that drafts up bundles on a daily basis to send to the court and to send to the advocate, because these are 5 minute hearings, and of course you have all these hearing lists and you have to put your evidence before the judge. And a lot of landlords, when they try and do it themselves, they don't really understand what the implications are when you have to go to court, and what you have to file, and what witness names you have to
file. Well, absolutely. I mean, it's a difficult situation in itself to be going into if you've never done it before. I mean, the court will try and make it as easy as possible, but at the end of the day, it is a court, and the judge is there to make a decision, and you need to get your ducks in a row. We have that sort of support staff, and so therefore it's easy for us to get it right. We were just sort of saying just before this webinar that you know, one of the problems with the court system is that they just don't have, you know, a digitalized system, so you can't just, you know, by and large, you can't send in your documents. There is obviously PCAR, which is great,
which is possession claims online.
And that's been great. That's been fantastic. But that's just on rent arrears. There are other grounds, and you have bundles of paperwork which you have to put together. And it's easy to get things wrong.
Yeah, and then I think currently, let's touch on antisocial behaviour. We're going to move on to the other. What's going to happen in the future. I mean, just a couple of things actually. Under the Renters Reform Bill, we're going to touch on this again later on in the webinar, and before you know it, time is upon us. Is antisocial behaviour is a big bane of a landlord's life. There might have an HMO, and there might be a tenant that's causing problems to other tenants or neighbours, and that's why Section 21 has been used historically, and that's why we need to hear further detail. And I believe under the new grounds on Section 8 is that there's going to be less evidence that's required under antisocial behaviour to be obtained to get the possession order. The problem you have with antisocial behaviour, and that's why Section 21 is so good for antisocial behaviour, is that witnesses or people that are intimidated or being threatened by this person who's causing problems in a block or in a property. And then we have a lot of issues with mental health, which is a problem as well. They don't have to write the witness statement because then you use under Section 21. Under the new rules now, and let's talk about Section 8, what it's going to look like in the future. I think one thing that I would want to raise is that mediation is really important, and it's going to form a lot of what's going to happen in the future. You know, the Ministry of Justice want to be able to lessen the amount of cases that go to court and go before the judge, where you can try and mediate and do a deal to get vacant possession. And what we did at the property redress scheme, one of our brands, is we started a mediation business when the notice periods went to 6 months. We still have a mediation business where we try and mediate between landlord and tenant to actually avoid court, which is always worth doing. But there is going to be a form of a mediation process that you've got to try and follow in the future when the Renters Reform Bill comes in. So let's just talk about it, and I'm going to ask you, I'm just going to run through these, Paul, and then I'm just going to ask you to put a bit more fat on, a bit more meat on the bone, essentially. Yeah, selling a property or a family member moving back into property, that will form one of the mandatory grounds in the new look of Section 8. Where the landlord is in breach of certain notices, license conditions, or has an HMO license revoked, will be mandatory grounds. There'll be mandatory ground for persistent arrears 3 times across 3 years. I'm not too sure about that really, because I think normally you wouldn't wait that many times. I think maybe a couple of times, but maybe 3 times is a bit too far-fetched to a certain extent. And there's going to be 33 grounds in total, 22 of which will be mandatory. So there's going to be loads more mandatory grounds. Do you want to just give us more information about what is how this new Section 8 is going to look like?
Yeah, sure. There are lots of different grounds. There's 33 of them there.
Yeah.
But there's probably 5 that are sort of important, which you've listed there in summary version. Looking at that first one, which is, I think, the key one, the reason for Section 21 being issued, property want to be sold.
And then on that, presumably you've got to give enough evidence, because some landlords might say, right, this is, don't forget, Section 21's gone now.
Yeah.
So you can't use Section 21. You've got to do Section 8. This process is being used effectively in Scotland at the moment.
It is.
And then, of course,
not in Wales.
And not in Wales. We won't talk about Wales because that's a lot more complicated, believe you me, to a certain extent. Is that supposed, you know, there's going to be, you've got to give enough evidence that you actually instructed and it is a proper sale.
Right. So first, at the moment, we've got ground one. As I said previously, you've got to give prior notice if you want to move back into the property. That prior notice will be abolished, so you won't have to give the tenant notice to say you want to move in. You can say, I want to move in, and put that as your ground. Me or a family member wants to move in, and put that as your ground, ground one. And then the new ground is ground 1A. That's the proposal, ground 1A, and that will be where you want to sell. Okay, so we'll come on to, you know, how that might work out in a moment, but the sort of just to give you the facts. The proposal at the moment for ground 1 or 1A, a family member moving back in, or you want to sell, is that you can't use that in the first 6 months.
Right.
That's the first point. And then once you've used it, and let's say you've got your order, particularly, you know, you've got your order, you then can't re-let the property for 3 months.
Right.
So the idea is that you're prevented from pulling a fast one, if you see what I mean. It's by saying, I want to move back in, or I want to sell, and then not moving back in or not selling. So that's the point. You've got you can't re-let for 3 months after. Now, there is a fine, £5,000. Right. So that's important to know. It does come with a hefty fine if you do that. But, and this is what Paul was mentioning there about, you mentioned about Scotland. You know, the problems there is that you know, from a, if you like, from a running or how this might work out, is that how do you prove that someone you know, has actually done that? The local authority is probably not going to be going around checking. It's probably going to be on the tenant that's gone, well, are they going to be bothered? So we'll have to see how that pans out. But I'm.
And what other mandatory grounds will there be?
Okay, so that's the big one. Section 21 going. They want to sell. That's one.
And there's rent arrears. What other ones?
well, there's some more to say on the rent arrears, but on the ground, the new ground 6A, which is the breach of certain notices. So, for example, there have been a number of offences since 2004 and were sort of made more hefty in 2016. That make that sort of look to regulate the landlords. So, for example, you probably have heard of improvement notices, banning orders, prohibition orders. Then there's the whole licensing scheme, different types of licenses. If you don't have, or if you do have a banning order, for example, or an improvement notice served upon you, you can use that as a ground to evict, and it's a mandatory ground.
Oh, so if you've been served,
yes. So,
right.
So it is a bit counterintuitive. I'll put it like this. I appreciate I'm talking to landlords here, and this is the but from a tenant point of view, they might say, well, the landlord's not done the right thing, but they can use that as a ground to evict me. So we'll see how that pans out. But that is the point, and I think that the thinking behind it is that this property is not in a good condition. The tenant shouldn't be in it. So I think that's the point behind it. But it does sound a bit counterintuitive. But that's a proposal at the moment. And then just to finish that point of under 21, obviously they were all there. So a section 21 would be invalid if you hadn't.
That's right. You can't.
So it's following that on really. And then on the ground 8, on the new ground 8, basically you're looking 3 days over 3 years. The point I'd say on that is that we'll see how this goes through Parliament, but I think 3 years is quite a long time. Essentially you could still have a good tenant that has a life-changing event, loses their job or a divorce or something like that, but they nevertheless can get back on track. I think see that reduced to 18 months perhaps.
Okay.
That's didn't go on to antisocial behaviour, but
that's fine. So we're going to touch on to it now. Right. So what current Section 8 grounds will be amended? It says grounds 1, 2, 6 that have had their prior notice requirements removed. Ground 8 has been updated so that a delayed universal credit payment does not count as arrears for purpose of court. So I'm going to obviously speak up for landlords. I'm known in the industry as landlord's friend. I'm very proud of being called. I've been called a lot of other things, believe me. But what I would say is that if a tenant hasn't properly put in their application for universal credit and it's been delayed, why should the landlord have hardship and not be able to take action and not be able to get a ground under Section 8? There is another problem that happens with universal credit. I'm a big critic of universal credit when it came out, because one of the worst laws that ever came into effect was giving direct payments to tenants with universal credit, because a lot of universal credit tenants unfortunately can't manage their money properly. And unfortunately, with regard to where we're at now with the rental stock prices, a lot more of the vulnerable tenants are going to and the banning of Section 21, when there's going to be higher level of referencing that's going to be carried out. Unfortunately, the lower earning tenants and the tenants on benefits will unfortunately come croppers. They'll lose out because they're not going to be able to find
I think the universal credit point, obviously you can get direct payments, landlords can get direct payments.
They can,
but the point is that
only if the tenant agrees.
True.
Yes.
But the point is that the universal the point is that where a housing element of universal credit hasn't been applied for, then that's different from the housing benefit department, universal credit not having completed.
Have you ever tried to get through to universal credit?
Well, very difficult.
I know one landlord that was on the phone for some of the best part of 4.5 hours, which is a nightmare. And then lastly, the ground 14 at the moment. And so I can tell you now that going to court for, subletting is rife, and I've written a lot of content about subletting in the past, and especially with Airbnb and all the stuff that happened, guaranteed rent and rent to rent. Landlords have become croppers of subletting without consent. And you go under ground 14 if you don't have a break clause and you can't use Section 21. They are discretionary grounds. They're going to widen the threshold to likely cause of a nuisance to capable cause of a nuisance. And I think that's important, but antisocial behaviour is a big problem and has really risen, hasn't it?
Yeah, it has. I think the absolutely it has. During COVID, we tried to use ground 14 more often to sort of reduce the notice period, because notice periods went big. Ground 14 is
That's
nil.
Yeah, correct.
So it's sort of drafted, you know, to assist, and I think courts are, and judges are very you know, sympathetic to landlords where they are dealing with. They don't want antisocial behaviour to happen. So they will crack down on it, but you still need to have the evidence. Now, the changes that we've got here, potentially going from likely to cause nuisance to capable of causing nuisance, very subtle. So we'll have to see how it pans out. But I think the point is that you know, if you have to have evidence, but evidence to show that someone might do it rather than that someone's actually done it. I think that is a subtle change, but may well assist.
Yeah, thank you. So look, we're going to talk about Section 21. We know Section 21 is going to be abolished in the next 18 months to 2 years. We're going to touch on time frames with regard to the Renters Reform Bill. The Renters Reform Bill that came in, which had 12 points and provisions put forward, are some of the biggest changes that have been brought into the private rental sector in some 30 years. If you, by the way, just a couple of things here, I'm going to just remind you, feed some questions through to us on our question panel. I'll try and whiz through the questions at the end with Paul and myself at the end of this webinar, which is not too far away. If we don't have time to answer your questions, my landlord action team, Paul and the team, will respond to all of these questions back. And you know, we've got years and years of experience. So known as non-fault, I remember doing an interview for Panorama when they first talked about Section 21, called it non-fault, and that landlords wanted to serve Section 21. So my defence was, I was on, it was more of a tenant-led piece, but I was on Panorama for 17 seconds when I came into the office, and I said there's always a fault. There's normally a reason why a landlord serves a notice on a tenant. They don't just serve it willy-nilly. You know, we know now, and we're going to come to it shortly, that the biggest reason at the moment for serving Section 21s is because landlords want to sell. Yeah. It's a 2-month notice that must be given to a tenant, cannot be served within the first 4 months of a tenancy. And I remember when I gave evidence and I was working on the deregulation advice, I came up with a couple of ideas, which actually ended up being a law. One was serving a Section 21 after 4 months, okay, and the other was to have a 6-month lifespan. Because initially in the old days, a landlord would serve, or a letting agent would serve, a Section 21 notice as soon as a tenant moved into a property, which was really bad practice. Or you'd go to court on a notice that was 4 years old, and it's not good enough. So that made sense to be brought in. As I said, 60% of instructions at landlord action relate to a Section 21 notice. And of course, in the future, that's going to be going. So more landlords are going to have to look at breach of tenancies and have to go to court and get court orders. But of course, let's be clear, 90% of the time, tenants leave a tenancy on their own accord. Tenants want to rent for a reason. You know, they want to be transient. Accelerated possession claims were approximately, it shouldn't be £20,000, it should be 20,000 in 2022, and it will rise. Okay, the most accelerated possession claims that ever happened, I can tell you now, was in, if I remember rightly, it was in about 2005. It was about 35,000 that we had. Okay, Section 21 will most likely to be abolished, as I said, in 18 to 24 months' time. So why are landlords serving Section 21 notice? One, because if you sell a property which is vacant, you're going to get more money than rather than having a tenant in. Because of course, don't forget, there's first-time buyers, or people want to trade up and they want to buy, and a lot of them are buying from landlords. As I said, 153,000 of those properties came out of the private rental sector last year. Tenants are in arrears. That's a really high proportion of landlords serving Section 21s. They don't want to go to court. They want to write off the rent. I just want my property back. I don't want to go to court under Section 8. A lot of landlords find when it's going to court and going before a judge, it can be quite intimidating and it can be very stressful. Landlords want to move back into their property. Remember, a lot of landlords out there only have between 1 and 3 properties. As I said, about 80% of those landlords are small landlords in that sense. They want to refurbish the property. They have an antisocial tenant in the property. They need to get them out. It's easier. You don't have to go under ground 14, which is a discretionary ground, wait for a hearing date, or wait for the advice for someone else or a neighbour that has to give evidence who were too scared because they're frightened of that person intimidated. And of course, a big reason, councils all over the country are still telling tenants stay put, wait until you get evicted, wait until the bailiffs turn up. And you know, I try to highlight this on Nightmare Tenant Slum Landlords, and I did 6 series, and I think it was 68 episodes over 5-6 years. I try to explain and show people out there that, and of course, it's very stressful for tenants. Tenants now going into temporary accommodation. I saw a report last week that for immigrants that are being housed in hotels under temporary accommodation, the bill has gone up in the last 10 years from £500 million to £4 billion. Okay, and that's just on people waiting for immigration status. We are in a temporary accommodation crisis. We are in a social housing crisis. We are in a rental stock crisis, and for years and years, landlords have been that sticking plaster for the social housing sector. I think it was what was it, something like 3-4 years ago? I can't remember when it was. I lose track of time. There were 6,000 council properties that were built in 1 year. I mean, that's ridiculous with a population of 70 million people. So going to court, and I want to get some feedback from you now about what's happening on the ground with regard to the courts, Paul. You're doing this day in, day out with your team. Okay, tenants are being advised to stay put and be rehoused by the council. We've explained that. 22,000 possession claims were issued this quarter, 24% increase on last year. Accelerated Section 21 rose by 34% quarter compared to last year. Let's be very, very clear, and I think there's a little bit of a skew with when it comes to figures. We had COVID. Don't forget, no one was evicting through COVID, so the figures went right down. They were very low. Yeah. There was no social housing evictions carrying out even a year later after COVID. Now there's a big backlog. So, you know, in 2019, which was pre-COVID, there was 110,000 possession claims that were issued. I predict in 2023, and I've said this a year to 2 years, I said this in 2020, beginning of 2022, I predicted that I think that we're going to come to 110 to 120,000 possession claims. We're going to start rising again. Don't forget, now the courts are going to get busier with regard to house repossession, because of course mortgage arrears are going to go up for homeowners as well. We have a shortage of judges, don't we, Paul? Explain some examples of cases that we have with judges. I know there's a massive problem with recruiting judges, isn't there?
There is a massive problem with recruiting judges. I mean, you know, they are doing what they can to recruit the judges, but just it takes time. I mean, whether a well-practiced barrister wants to give up what they're doing and go and work in some of the county courts, you know, that themselves aren't in pretty good condition, I don't know. But you know, it is taking some time. What we have found, and you know, I'm not saying this never happened in the past, but more and more recently, you know, over the last 6 months, in particular, Landlord Action, is that we get a notice, you know, the day before. There's no judicial availability.
And don't forget, a landlord's been waiting months for this hearing date. It's really, really hard, because we end up becoming, you know, we speak to landlords all the time, all different types of landlords all over the country. Some of them really desperate, some of them are coming under hardship. Not all landlords are millionaires and drive Rolls Royces, believe you me, and they're not banks as well. And it can be really distressing for landlords. Of course, it's distressing for tenants. You know, I think a big problem that we have is that there's a real lack of communication. Tenants don't bury their head in the sand or don't correspond, and rents aren't being paid for months and months and months. And landlords have got to wait longer and longer. As I've said in this slide deck here, I've been involved in the court system. I first went to court when I was 16 in 1987. I started doing landlord and tenant in 1990, 1991. I've never known the courts as bad as they are today. I listened to a webinar of a judge called District Judge Kemp in Romford County Court. And this is when we had review hearings and we had a whole COVID backlog and backlash and everything that was going on. And he said that, I mean, if you look at the court buildings, they're old, they're decrepit, they're falling down effectively. He said that he has a bucket in his room because there's a leak and stuff. I mean, that's why I think now, after going through COVID, I was a little bit skeptical beforehand. We need to put the conversation of housing courts back on the political agenda. I mean, and that has been kicked into the long grass because it's all about the Renters Reform Bill, but you can't abolish Section 21 unless you have an recruitment of more judges and more bailiffs. You reform Section 8 so there's more grounds. Landlords need confidence they can get their property back. You need to bring mediation in, okay? That you need all these mechanisms. Now, it's all right for tenant groups like Shelter and Generation Rent saying, you know, and I've called them out. And I wrote a blog, and if any of you want to read a blog that I've written, which is on LandlordZONE, if you click on LZ Voice, I said stop demonising landlords. These tenant groups aren't helping because they need landlords, and you can't keep fighting landlords, because if you keep poking the bear's going to bite you back. And that's what we're seeing. We're seeing lots of landlords leaving, which means lots of good tenants are having to leave properties, aren't they, Paul?
Yeah, they are, absolutely. It's it is very difficult. I mean, I think another solution, I think there's a number of solutions. Another one that I could throw in is the costs. If you were able to get a tenant solicitor's costs limited to a certain amount, then it would encourage settlement a lot quicker. It would use up less court time. Judges' time wouldn't be so precious. But I think, you know, that along with the housing court and other initiatives, you know, perhaps once the Renters Reform Bill is in place, will help. But it's a multi-faceted problem.
Yeah, and we've got a case study here. I picked this up when I was writing this last week and speaking to the staff. A possession claim was sent to Clerkenwell County Court, which we believe is one of the worst courts in England, by the way, on the November 2022, and we had a response that wasn't received until March 2023. This is one of the, and again, the court delays are becoming a joke, and it's really hard having conversations with landlords that are desperate to have their property back. And we're saying, well, look, we're having to wait for the courts, and we literally have someone in our team as part of her job. She is trying to chase the courts up. And trying to get through to the court, you've got more chance of getting through to the Prime Minister, haven't you?
I'm afraid so, yeah. I mean, she's great at multitasking, so she'll do other things.
She'd just be on hold, won't she?
She's just on hold, getting on with other things, but eventually the phone call, sometimes it gets to 1 hour and they just cut off. It's a nightmare. Yeah,
now I'm conscious of time. I'm going to talk about bailiffs, and then we're going to try and do 10 minutes of questions. I've got some questions that have come through, so feed your questions through, and I'll try and read them out on the air. If not, do not worry, I will make sure that our team come back to you. Section 8 evictions have increased by 27%. Accelerated possession evictions have increased by 47%. Accelerated Section 21 evictions in Wales increased by 157%. The reason being is that they changed their whole procedure into obviously contractual agreements, and everything changed, and then of course it was post-COVID. Don't forget, we are now seeing the after repercussions of what's been going on. There's 27% increase in bailiff evictions across the board. In London courts, this is where I had to write something, and I tried to speak to some stakeholders. There was an 80% less capacity of bailiff capacity carried out because they said there was a lack of PPE, right? Now, we found out that supposedly that they'd ordered stab vests and they were the wrong sizes. Really, what should be happening, and we do this at Landlord Action, so when we go to court on a Section 8 case, we will plead that we want the case transferred up under Section 42 to use a High Court sheriff, okay, which means that we can carry out an eviction generally in 4 weeks. We've been waiting 3-4 months. There was one in Central London County Court. What was that, about 7-8 months, wasn't it, if I remember rightly? Yeah. That's another 7-8 months lost rent. And of course, now landlords' mortgages have gone up. There is a need, and I say this when you ban out the Section 21. You know, if you've got a shortage of bailiffs, and the best part of bailiffs is being paid £22,000 to £25,000 a year, and now it's harder than ever before to be a bailiff. You've got to go in pairs. There's a lot more mental health. You never know what's behind the door. And then, of course, we had COVID, and there was all that type of stuff that was happening. You should have the use of using High Court enforcement officers, and they should use High Court enforcement officers, or there needs to be some amendments that if you get rid of Section 21, you still have faith that you can get an eviction date. At the moment, it's a nightmare. We have a social temporary housing crisis, and I believe that there's a bigger picture here, and that's why things are being slowed up. There might be a bigger directive, we'll never know that, but I'm saying what I feel because I've been in this industry a long time. I worry about this. Renters Reform update. So what are the timings? This is important. It's coming in, right? It's definitely coming in. The second reading should take place between now and Christmas. Thereafter, there will be amendments to the bill through the House of Lords and Royal Assent, and a general election, we think, in 2024. And there's a good chance, obviously, there could be a Labour Parliament. Whatever Parliament comes in, the Renters Reform Bill will come in. They want a fair deal for renters, and I understand that because, of course, tenants need and want greater security. They want the stock and the quality of the private rental sector to be better. Supposedly there's 21% of the private rental sector stock does not fit the decent home standard. The bill is being brought in as again to offer greater security. And this is the biggest shake-up in the 30 years. What are the main challenges? The abolishment of Section 21, periodic tenancies. Now it's been highlighted, and I must say the National Residential Landlord Association have done some great work in campaigning and lobbying the Parliament with regard to periodic tenancies. So that's going to be a challenge. How does that work? And court reform. Everything else, which is basically property portals, a landlord redress, makes total sense. Everything else, it can be dealt with, but we wait for the detail. There's a lot more work that needs to happen. So if you have an issue, if you need some help with regard to eviction or tracing a tenant or debt recovery, these are our details, okay, at Landlord Action. You'll see Paul's and my details at the end of these slides as well, okay. So our website is landlordaction.co.uk. And then look, I do recommend, as a landlord, it's harder now being a landlord than ever before, okay, especially fully managing your property. Please scan this code at LandlordZONE. We'd love you to become a subscriber. It doesn't cost you a penny. Information is power, knowledge, okay. The changes, we have a brilliant editor called Nigel Lewis. We do 3 to 5 breaking stories a day there for landlords. We have a great forum, and actually in the next few weeks we will be updating our website. We've got a brand new website that's going to be launched for our subscribers with a better unique experience for the user. But please highlight this code. You can and become a subscriber, and then of course you'll get all the updates. I write regularly, and we do webinars. We're going to be doing webinars once a month now. Our next webinar next month, I believe, will be on EPCs, what's happening in EPCs, and then the month after will be with one of our partners, landlord sales agencies. So look, today's webinar has been brought to you by Total Landlord, how to be a total landlord. What I would also recommend is that there's lots of landlord events out there. Go to them, get updates. You can hear people like me speak. As I said, I'm doing an event called Landlords How to Survive on the 19th of October, and I will give you our email address, but please go to Total Landlord Insurance. You know, it's really important. What happens if you get a cannabis factory at your property, Paul? Your normal insurance, your home insurance won't cover you for that, you know. So look at the cover, and you can get a policy as little as £100 to cover you. It's important. You know, your property is your biggest asset, isn't it? It's really important. So look, there are our contact details. I'm going to leave that on there. Should we do some questions? Yeah. That's not bad. We've got 8 minutes. Okay, here we go. I'm going to whiz through these. Paul, I want quick answers. Now, I know you're a solicitor, and you solicitors do like charge by the hour. I'm going to charge you fixed fees. I'm going to charge you by the second. All right? Okay. So I'll answer this first. When will Section 21 come in force? Well, Section 21 is in force now. The abolishment of Section 21 we think is going to happen in 18 to 24 months. Right. Next question. This is from Claire Payne. Do you think the government will bring back the reform of tax changes given the landlords leaving the sector? I can answer that. I totally believe that there should be incentives given now for landlords to stay in the sector. They should look at, they should definitely be looking at the abolishment of Section 24. The reality, Claire, it won't happen. There's too much coffers that are going into the Treasury, unfortunately. There needs to be incentives for landlords. I would say to you, important landlords, you need to think about how you are incorporated. Are you a company? Always get tax advice. It's really important. Let me give you this. Okay, how much would it cost a landlord to go through the Section 21 notice process by themselves? Well, again, I'll answer that quickly. You can do it. It's cheaper being a landlord, but it's like anything. You know, if you have a leak, do you want to do it, or do you want to get a plumber to do it? I would say, even if you know, use a regulated solicitors, right, to do this. There's a lot of unregulated solicitors out there that do it themselves. Get someone that's an expert and do this. You know, if you have your boiler, you'd get a Corgi gas registered boiler plumber to do it for you. Landlords can do it. The Section 21 6A forms are quite simple now. You don't have to do it a day before the rent date. It's easier. You've got to give at least 2 months notice. The court fee is £355,
Yep.
but issuing a claim at court is difficult. You know, you make one mistake, case gets dismissed, you lose 4, 5, 6 months, you're back to square one, aren't you, Paul?
Especially on 21, yeah.
Especially on 21. Okay, question to you, Paul. This is from Bill Palmer. Would it be better to serve a Section 21 now before the new law comes out, just in case it becomes difficult to evict next year?
Yeah.
Okay.
It's the short answer to
yeah,
that.
I mean, look,
it depends why you want to get the property back.
Well, I think, look, let's be very clear. If you've got a tenant who's a good tenant, paying their rent, looking after your property, giving you access into the property, why would you evict them? Yeah, your tenant is your customer. Okay, good tenants are important to keep hold of. Yeah, you need they're good weight in gold. If you are looking to exit the market, then yes, most probably you would want to serve a notice. As I've said many times before, you are going to see even further landlord panic when there is going to be that abolishment date coming in. I've told the tenant groups, I've told the government this. It is my worry. But if you've got a good tenant, you want to keep them there. You want your tenant to feel that that property is their home, because they do that, they want to stay. Question for you, please, Paul, quickly. Dawn Coleman wrote this in. Where do we stand as a landlord when a tenant is arrested and held awaiting a hearing?
Well, the point is that you need to ensure that they are aware of the hearing.
So they need to be served.
They need to be served. You need to contact if they are being held in prison. You need to find out where that prison is.
Yep.
Find a prisoner.
You have to get the prison number and serve the governor. I've done that before as well.
You need to ensure that the prisoner is aware, and then it is for the prisoner to ensure that they get the advice and representation. That is possible, obviously, through legal aid, etc., but that's your duty.
Or what Dawn can do, she can take your email address now, which is there on screen, paul.sowerbutts@landlordaction.co.uk, and email you.
Yeah.
Okay. You can email, and Paul will be able to come back to you. Is this session being recorded? This is by VJ. Yes, it is, and we are going to email all the people that registered for this webinar, so you will get an email about this with a copy of the recording, most definitely. My next question from Paul Trumper: is it worth your tenant to vacate your property when they are being advised by the council to stay put?
Is it worth the tenant? It's not. It's not worth it.
No. The tenant wants to stay there until the end.
They're going to do
because
what they're told.
Otherwise, they make themselves voluntarily homeless.
Yeah.
They have to stay put, and this is the biggest bane of my life, where I know that Brandon Lewis, who was the housing minister 8 housing ministers ago, whenever we've had more housing ministers than you've had hot dinners, obviously, he turned around and he wrote a letter to all the councils saying you must not advise them to stay put, but they're still doing that. We know that as a fact.
The tenant can take action against the local authority. That's one thing. It's not in the landlord's gift, but a tenant can take action against the local authority if they're told to stay. So that's something to bear in mind. Okay.
Question from Alexander Weeks. I'll give this to you, Paul. Do I have to wait for a county court warrant before getting a high court bailiff? Do you want to explain about the leave and stuff, how that works?
Yeah, I mean, essentially at the hearing, at the possession hearing date, we will, as a matter of practice, we will ask for permission to transfer up to the High Court. If you get that permission,
you've got to get the leave from at the hearing date.
At the hearing date.
It depends on the judge. Correct?
Yeah, it's not always granted, and most of the time it isn't, to be fair. But if you do get that, then you've got the permission, then you can transfer up. You don't have to wait for the bailiff. Absolutely. But you need that permission in the first place. You can make an application afterwards, but
I mean, we
wait for the application to be listed.
Yeah, I mean, I had a meeting where I spoke to a few stakeholders, a few organisations about possibly a judicial review, because people are paying for a service and they're not getting the service because of what's been held up. We need judges to grant more leave. If you've got a landlord that's got thousands of pounds in debt, they have to explain at the hearing about their financial hardship, and they have to hope the judge says, you know what, I'm granting leave to transfer up. The problem is a lot of organisations and a lot of landlords are trying to do themselves, they don't plead at the beginning of the case. No. Or then you have to make a separate application.
Yeah, then you've got to wait for the application to be listed. Okay. No, we will do that. We'll get that.
We'll do that, but we are in the hands of the judges.
We are.
Yeah. Last question. We're doing right for time. We've cracked on here, Paul. Okay. Can I apply to the court? This is from Addy. Can I apply to the court for evictions without a solicitor, oh, sorry, let's start again. Can I apply to court for evictions myself without a solicitor after serving a Section 21?
Of course you can.
Yes, you can.
You've got to pay the fee, but you can. You don't want to do it, however, if you're going to get it, unless you're going to get it absolutely 100% right. Because it will just be chucked out.
I think that, look, on that point, and I'll leave it on that point, the reason I started Landlord Action with my old business partner, who was a landlord, and what happened was I helped him evict 23 illegal immigrants in a 3-bed property in northwest London. I did it for fixed fees, and out of that we started Landlord Action. And then in our research we found that every time you spoke to a solicitor, every time they wrote a letter, every time they were charging hourly rates. We want to do fixed fees. I would say there's a lot at stake if you get it wrong. You know, we pay that we charge for the best part of maybe £1,500 from start to finish, start serving those, issuing court, we get the bailiffs, including court fees, advocates fees and whatever. We try to do it more affordable. It's like anything, you just need to know what you make sure you know what you're doing, because the old saying, cheap is always expensive.
I thought know that.
You obviously didn't know that. I put that. Okay, so there are questions. We now are at the end of the webinar. How's that for timing? Not right at the end there, 12 o'clock. So we did an hour there. I hope you enjoyed it. Please give us some feedback. The recording is going out. That's going to be followed out in the next couple of days, so you'll get a copy of the recording. Take care. And you know what? You landlords do a great job. And evicting a tenant is always a last resort. Thank you.